Will the 19 ongoing commission-based lawsuits be moved into one single venue, one single courtroom that's going to adjudicate all of these ongoing commission-based lawsuits? Well, that's the big question right now. And believe it or not, both sides, from the plaintiffs, or a majority of the plaintiffs, and the defendant in this case, NAR, want that to happen. So here's what we're going to do. We're going to explore that together. And this is actually coming to us from NAR itself, right? So this just came hit the newsroom. So NAR supports centralization of compensation lawsuits, but the association is challenging the plaintiffs, saying the cases should be moved to Illinois, where most of the outstanding litigation originates. So as mentioned, we have both sides. We have the plaintiffs, in this case, and the defendant, at least one of them, we're not talking about the rest of the brokerages, are both petitioning for it to get centralized. But the argument here is to where. With NAR, you're looking at Illinois. Why? Well, NAR, it lists out its points, so we'll go on why that is the case. But a large part of it has to do, well, that's where NAR's located, in Illinois. And the plaintiffs want to see it in the Western District of Missouri. So let's read. Last month, plaintiffs in some of the ongoing antitrust lawsuits concerning broker commissions filed a motion with the Judicial Panel on Multi-District Litigation, asking the panel to centralize and transfer various cases to the federal court in the Western District of Missouri. Here's why. Where the Setzer-Burnett case was tried. Now you may be wondering, well, why do the plaintiffs want to do it? Do they want to minimize fees? Do they want to make it easier on themselves? Do all this other stuff? Well, while some of that might be true, because the plaintiffs, there's 19 ongoing. Let's read this and then we'll kind of break it down. Centralizing 19 currently pending commission lawsuits, but disagrees with the plaintiff's arguments, blah, blah, blah. The best place would be Illinois. Okay, yeah. So of the 19, not everybody is requesting that, but some of the plaintiffs are doing that. Now, again, why would that be the case? You can't really say the quiet part out loud on why they want to go with the Western District of Missouri, but the real reason that they want to do this is not to make the legal system more efficient, for them to save cost or anything like that, because most of them are not paying the attorney anyway until they actually win. So until the attorney gets their cut. The reason that they're doing this is because they know what that courtroom has done in the past and who they favored in the past in terms of who has won the lawsuit. In this case, they know that the Setzer-Burnett case was tried, adjudicated in basically in a couple of hours, and the deliberation, and NAR was found guilty along with the other brokerages that were implicated at that time. So if you have evidence, like actual evidence, that this particular court has already rendered their direction in one way, so they've already sided in one way, well, let's bring the rest of them here, because we know that courtroom's going to be most likely favorable. Now, is that how the judicial system works? Well, it shouldn't, but just depending on what district you end up going, you can kind of guess the results based off of just data, just going online and seeing kind of where they side. There's reasons that high profile cases get moved to certain spots, right? There's a reason, if you're trying a lawsuit of, let's say, technology, if you will, Silicon Valley to be exact. So let's just say those types of courts, the courtroom is going to be very favorable if you take it to the northern districts in California. Now, if you're on the political spectrum, now regardless of where you lean, right or left, there's a certain bias, or there's a certain it's very lopsided in terms of the results if you take lawsuits over to the Southern District of New York, right? So there's and if you just Google, you're going to see some high profile cases all the time, but very recently, and what's getting litigated there, and why all of the lawsuits, that while the infractions or the legal, where the accused, or where the infraction happened, or where the law was allegedly broken, it's not being tried in those districts. It's being tried in these types of in these areas that you tend to know are going to be a little bit more favorable to your cause. Now, again, answering the same question, is that how the legal system works or should work? No, but it's how it is. So they can't say the quiet part out loud, but essentially it's, hey, since they've already ruled in the plaintiff's favor there, let's bring all of them over. Let's bring all of them over and not risk it in all these different jurisdictions, because yes, there's a cost, there's all that other stuff, but that's not even the big thing. It's more of the outcome. Where can we stack the deck in our favor? And this is where it gets into why this happens typically, at least on paper. But again, saying the quiet part out loud, they know that they're going to get a more favorable ruling, most likely because of the historical precedent that's already been set. Centralizing cases with overlapping factual issues into a single multi-district litigation can create a more efficient legal process that avoids inconsistent rulings and conserves the court's parties and resources. NAR's view is that all relevant cases should be included in any consolidation, including buyer and seller cases, and the Northern District of Illinois is the best place to address the industry-wide issue these cases present. NAR believes that the Northern District of Illinois is the most appropriate place for these cases to be transferred to, and these are the reasons that NAR gives. Now, yes, I am a member of NAR, of course. I'm a practicing real estate agent, and I'm gonna have a bias for sure. But if I was trying to my best to, kind of see if for some reason they grant this, right? If for some reason they grant that all of them get consolidated into one, I would actually go on the NAR side, because you're talking about 19 different plaintiffs going against one. And I know that there's brokerages that are implicated in a majority, if not all, of the other lawsuits that are going on right now. But the centralized location, everything happens to be at NAR. So NAR happens to be named in all of these cases. So I would actually err on the side of NAR, because it's 1 versus 19 for the legal expenses and everything else that goes on. I would actually err towards the Illinois side as opposed to the Missouri side. Now, my bias, of course, did I disclose my bias? Yes, I just did. But you can make of that what you will. It is the district in which the original commission cases were filed and remain pending. Fair. So that's where they get served, essentially, is another way of saying it, because that's where they are. It is the only district with both buyer and seller cases pending. Okay, I did not know that. It is the district with the largest number of cases pending. Again, that's where NAR is. NAR headquarters, and therefore much of the discovery related to its cases, is in this district. There it is. The district has experience with NAR rules. Fair enough. Chicago is a central location that is easily accessible to all parties. That's true. You can't really, Missouri is central, but as far as the airport and everything else, it's not necessarily can't really compare. NARS also says it would not oppose the cases being transferred to the Eastern District of Texas. Why? Well, where the cases with the largest number of defendants are pending. And also, you're going to have a more favorable ruling in the Eastern District of Texas. Now, without getting into too political, by the way, I listen to a lot of attorney podcasts and all this other stuff. So I do kind of understand how the legal system works through personal experience, and also just seeing what's happening in the news and listening to all these podcasts. So the Eastern District of Texas would see the NAR side a little bit clearer. I'll put it that way, which is a good thing for us, right? So that's why you want to play in the home field as much as possible. And again, should the legal system be this way? It shouldn't, but is it this way? Yes, there are biases. You present the same facts to all these districts, and depending on certain favors or certain biases, you can pretty much guess how they're going to rule one way or the other. That's the political system that we're playing in. But anyway, that's interesting. No verdict has been given yet. Of course, there's still this is something that just came via NAR, that they are also in favor of this. If that were to happen, I'll let you know. But outside of that, let me know what you think about this particular move. Should all 19 move to a centralized courtroom or a certain district? And if so, where? Let's see what we got.